Mr. Buzbee, you may resume. I think that mic's not on.
I want to close this loop on these documents. You heard my colleague, Mr. Hardin, say that these documents had never been produced to us. We haven't seen these documents. Your Honor, the documents are bait stamped with their bait stamp. They sent the documents to us, and then when we sent our exhibit list back to them, it was sent to Mr. Hardin, and I'm told he failed to forward it to the rest of his team. So, you know, I've withstood a few criticisms from Mr. Hardin, which is fine. You know, that's his job. But to suggest that he's never seen the document, that we didn't give him the document, and to object to a document that he gave to us, pretty ridiculous. So we would offer into evidence the two documents that we were discussing before the break, just to confirm AG 368 and AG 361.
If I may, I told the court that I would look into it, and I think I have it. I think I have the sequence right. This was a document that the AG's office produced to us in August, and in compliance with your order, we tried to turn them around many times within 24 hours, certainly as soon as we could. We produced this document, along with a lot of other documents, back in August, so almost 2 months ago. When we produced it, it was produced in mass, just like this. It was never listed on their exhibit list, and it was never listed as a proposed list. I'm sure Mr. Buzbee maybe inadvertently spoke now, I'm sure not deliberately, but he didn't add that when the first time we knew they were going to list it as an exhibit was last night. And the first time we saw it as an exhibit and type was today at noon. That's what led to all this hullabaloo. It is a forensic report for the court to understand that was done back in 21, where the agency, after these people left, went to all their computers and did a forensic report looking for evidence and things. And in this one, this was a forensic report done on the computer of Lacey Mays. And that's the sum total. So he is right in that we produced it to him. He's somewhat misleading in discussing when we got it as an exhibit, and we're on notice it was going to be offered as an exhibit. But now that we've looked at it and all, I'll be glad to waive my objection. We'll be glad to have it be admitted and let the jury look at it and understand what it is.
Thank you. Mr. Hardin. Yes, so he doesn't object. You can enter it into the exhibits.
Yes, Your Honor, thank you. I want to make sure I understand. Put it back on the screen, please. Actually, let's just make sure we focus on what this witness sent. Eric, put 368, AG 368, which is now in evidence, that we received. You can see, go to the email sent by this witness. Now, sir, I want to make sure we all understand this. You went to the FBI on September 30th, the day before you sent this email, right?
Yeah, he enlarged it. Can you put the date so I can, I'm sorry. Can we, the Madam Court Reporter keeps telling me that when I look at the document, I don't speak into the mic, and so I'll try to be deliberate. Yes, it is dated. It looks like if this date is correct, is October 1st, 2020.
Listen to my question.
Yes, sir.
You sent this email the day after you went to the FBI, isn't that right?
You know, now that I see that date, that time, there's no way Jeff Mateer is up at 1:39 a.m.
So you dispute the email that was sent from your email address?
I'm not, no, sir. What I'm saying is it has a date stamp on it with a time stamp. That there's no way I sent it on that at that time. I'm not disputing that I sent an email.
On that date?
I think that date or the day before, the timing could be somehow screwed up on the computer. I don't know.
Let's make sure we have a clean record and everybody knows what was going on. You went to the FBI. You reported what you claimed to be crimes. And then And then you told one of your subordinates to allocate $50,000 for a lawyer. Isn't that right?
To set aside unobligated reserves in the event we did enter into an outside counsel contract, and the we being the agency.
And you did that. This lawyer, Mr. Sutton, who represents you now, was supposed to be helping Ken Paxton some way?
Potentially, we wanted to meet with Mr. Paxton on October 1st.
With a lawyer?
No, it was going to be just the deputies first, but perhaps that could have led to that had he met with us.
So you wanted a lawyer to meet with you with the AG? I'm trying to figure out, why are you using state monies for a lawyer for your personal use?
I wasn't, and I didn't, and I wouldn't.
I guess from your point of view, it's okay to step outside of the procedure when you want to hire an outside lawyer, but it's not okay for the elected attorney general to do so. Is that right?
That's absolutely false.
Now, are letters sent by the Attorney General of the state of Texas official documents?
Yes,
They are official documents, are they not?
I believe so.
Let's all be clear. According to the former first assistant, your position is that letters sent from the AG's office are in fact official documents, correct?
They're documents from the office, and they would be, depending on the subject matter, I believe so.
Are you familiar with Texas Penal Code 37.01?
You've got it on the screen.
Let's look at it. Let's bring it up where we can see it, Eric. Can we have it bigger, Eric? There we go. Now scroll it where we can read it. Tell me if I get this right. A person violates 37.10A when he knowingly makes a false record in or false alteration of a government record. Did I read that right?
You read the document, yes?
Before I showed it to you and read it to you, were you familiar with that particular provision of the Texas Penal Code?
Sitting here, perhaps, I don't know.
Exhibit 127, Exhibit 19, please, Eric. All right. What we have here is a letter sent on the same day you guys went to the FBI by your subordinate, Mark Penley, correct?
That appears to be a letter September 30th to Mr. Kamek from Mark Penley, correct?
Who altered this government record?
I don't follow you.
What?
I don't follow you. I don't think this document was altered.
Do you see the letterhead that this letter was sent from?
I see the seal of the Attorney General on it, yes.
Do you see the Attorney General's name?
I do not.
Who removed it?
I don't know.
Would you ever countenance that?
I'd have to know the circumstances.
Well, these are the circumstances. It's September 2020, and your subordinate is sending a letter, an official letter from the AG's office, and he removes your boss's name. Would you ever countenance that?
Again, we'd have to ask Mr. Penley.
I'm asking, would you ever countenance that?
I don't know in this situation. I don't think this letter was altered because it does have the seal.
Would you authorize that? Would you authorize removing the duly elected Attorney General's name from official correspondence? Would you authorize that?
Again, I don't know if that's required or not.
Would you do it yourself?
I am anticipating that you're going to show me a document.
I am indeed. My question is, would you have done it yourself?
I don't know if Mr. Penley focused on that. I don't know if I focused on it. We obviously didn't. We don't print out the letters. They're brought to us and we sign them.
Yeah. Somebody, this is not a situation. I mean, this is an official letterhead of the office. Somebody had to do whatever it takes to remove the duly elected Attorney General's name from the official letterhead. Isn't that right?
I don't know what the process would involve.
Exhibit 30 within 127, Eric. Last page. Nope. There you go. Do you see that on the same day you were allocating $50,000 for Johnny Sutton, you were also sending a letter to Brandon Kammick?
Again, we discussed what we did with regard to Mr. Sutton. I do see that I sent a letter or signed a letter on October 1st, 2020, sent via.
You signed an official correspondence from the Attorney General's office of the state of Texas that had his name removed. Isn't that right?
That's what this shows. I did not focus on that at the time.
Who gave you the authority to do that? Who gave you the authority, someone that you've already admitted have never run for office, have never gotten a vote, the authority to alter the official letterhead of the Attorney General's office?
I mean, as I mentioned to you, Mr. Buzbee, I didn't do that. I signed a letter.
Well, who did it in the office? That somebody had to be working for you because you told us you control the day-to-day activities of the office, remember?
I don't know who did it.
And it was just an oversight on your part that you were signing a letter that had your boss's name removed? Is that your testimony to these jurors?
My testimony is that is not something I would have been focused on October 1st.
You were involved in staging a coup, weren't you?
Absolutely not.
That's what you were up to.
Absolutely.
That's the reason you went to the governor's office. That's the reason you were talking to TLR. That's the reason that you had or engaged in conduct removing your boss's name. You were staging a coup, weren't you?
Absolutely not.
The Mitty Foundation, we saw that you signed off on that, right?
We reviewed documents that I approved the investigation and I approved the intervention, correct, sir?
You remember you talked about you came back from vacation and that you realized, you found out that a legal opinion had been issued. Remember saying all that?
About the foreclosure?
Do you remember saying?
I'm asking for clarification,
Yes, sir.
Is it about the foreclosure letter?
Yes, sir.
Yes, I remember.
You called it a legal opinion, didn't you?
If that's what the record shows, it was a legal opinion. It was done by lawyers, the Office of Attorney General, under, I believe, the disaster authority.
In fact, Eric, put on the screen, please, Article 2 of the impeachment articles. All right, I just want to, for the sake of clarity, one of the charges in this case is that General Paxton misused his official power to issue written legal opinions under subchapter C, chapter 402 Government Code. Do you see that?
I see what you've read, yes.
Now, let's look at the legal opinion that has been referred to. Go to Exhibit 12741, Eric. Before we turn the page, why don't we look at the official letterhead of the Attorney General's office? You see it there?
I see, yes.
Of course, that's not the letterhead that you used on October 1st, is it?
No, the two documents are...
You altered it, didn't you? Or you had it altered?
No, sir.
But focusing on Article 2 of the impeachment articles, go to the second page, Eric. Actually, third page. It's the last page, Eric. There we go. Would you do me the favor of reading the very last sentence in that paragraph?
Okay.
Please read it loud so our jurors can hear you.
Again, please note, this letter is not a formal Attorney General opinion under Section 402.042 of the Texas Government Code.
It's pretty clear, is it not, that this letter does not fall under legal opinions as defined in 402.042, correct?
Well, Mr. Bangert says what it says. It's not a formal Attorney General opinion.
Right, but the article of impeachment says it is. And you know, as a lawyer, it fails. Right there, dismissed, right?
I don't know that.
Well, I mean, you allege, hey, you violated, you did something wrong, you issued an opinion under 402.042, and it takes us literally 20 seconds to show that's not true. That fails, right?
I don't know what you're asking me.
It's like almost like somebody read the first 2 pages but failed to read the last page when they drafted these articles, isn't it?
You're asking me to speculate concerning...
How many foreclosures did this letter stop?
I don't know.
None. Did you know that?
I don't know.
Now, grand jury subpoenas are supposed to be secret, is that right? How does that work? Do you know?
I don't know.
Okay. Are you supposed to, would it be appropriate for somebody in your office to send issued grand jury subpoenas, copies of them, to some sort of outside lawyer who's not involved in the case?
I think it depends on the circumstances.
Was it appropriate to send the grand jury subpoenas that Mr. Kamek had issued to Johnny Sutton?
I believe in this circumstance it was.
Was Johnny Sutton the office's lawyer at that point when that was done?
Johnny Sutton was never the office's lawyer.
Okay. Was he your lawyer when that was done?
What date was it done on, sir?
Exhibit 35 of 127, Eric. Wait a minute. Hold up, Eric. Let me make sure I got it right. Let me just, before I grab the document, when would it ever be appropriate for either you or any of your subordinates to send grand jury subpoenas or copies of them to some outside lawyer who had not been hired yet?
Object to the form. That's a misstatement. He doesn't know. He doesn't know when he'd been hired.
Well, let's figure that out. If you're asking me, I'll ask him. We were told previously that, oh, you can't know when he was hired, so let's figure it out now. When did you hire Johnny Sutton?
I believe we retained him during that last week that I was First Assistant Attorney General, personally.
Wait a minute. You're telling us that you hired and retained Johnny Sutton while you were still at the office?
Correct.
And at the same time, you're allocating $50,000 to retain him?
And we make the decision not to do that.
Wait a minute. Okay, help me on this. If this is news, you're saying under oath that while you were an employee of the Attorney General's office, before you resigned, that you had already hired Johnny Sutton. Is that right?
I believe that's so.
What day?
Whenever that first contact was.
He says in his subpoena, trying to quash the subpoena, it was before you went to the FBI.
I think that's correct.
Okay, so now we're all clear. You personally had hired Johnny Sutton, an outside lawyer, in your individual capacity before you went to the FBI. Is that right?
Correct.
And at the same time, in fact, the next day on October 1, you were telling Lacey Mays and the comptroller to set aside $50,000 for Johnny Sutton?
For the office to retain Johnny Sutton.
Well, you were going to have Johnny Sutton represent you individually and also the office, and you were going to have the office pay for it?
No, that's not correct. I mean, it is not uncommon.
You realize now what you just testified to?
Could you let him finish, please? Just finish his answer.
Do you realize what you just testified to?
No, sir.
You just told this entire jury that you had hired an outside lawyer in your individual capacity before you went to the FBI on September 30th, 2020. And the very next day, you were instructing your subordinates to set aside $50,000 for Johnny Sutton.
And the agency never hired Mr. Sutton. The agency never paid any money to Mr. Sutton. The funds were never used in that way. The decision that we made was the agency not to hire him. That never happened.
The decision we made?
Me and the other folks.
Can you help me understand? I guess you told me now Johnny Sutton was your individual lawyer while you were still at the office. Was he an individual lawyer in the individual capacities of other of your subordinates?
I believe so.
And so your testimony would be that if your subordinates were sending secret subpoenas that had been issued by the Travis County District Attorney's Office, that they were able to do that because Johnny Sutton was their personal lawyer?
I believe it was done pursuant to a request from the FBI.
To send to Johnny Sutton?
To send to Sutton and then to the FBI. That's what I understand.
So the FBI, these subpoenas that everybody's complaining about, at least those folks, were sent to the FBI 3 years ago. Nothing's happened so far, right?
I don't know if nothing has happened.
Are you here testifying in any way that Nate Paul had anything to do financially with the renovations of Angela and Ken Paxton's home?
I only know what I've been told.
Told by who? Again, you mean Rylander and Wicker?
Remember, I testified before lunch about that, sir.
Okay, did you ever make any effort to confirm that what you had been told by one of those two was correct?
I did not.
Okay, you just believed it.
I believe Mr. Wicker and Mr. Rylander are truthful people.
Did they ever look at the invoices?
You'd have to ask them, sir.
I will. I'm asking you. Did you ever look at?
I never asked them if they looked at the invoices.
Do you have any evidence whatsoever, other than what somebody, and you're not sure which one, told you that Nate Paul had anything financially to do with the renovation of the Paxton's home?
Did you say that again? I'm sorry.
Do you have any evidence, to support any allegation that Nate Paul paid for any of the renovations of the Paxton's home?
Other than what we discussed.
Pass the witness.
Mr. Mateer, let's cover a couple of things, hopefully very quickly. Let's talk about this forensic report that he introduced as Attorney General 361. And he talked to you about, I'm sorry, do you want the, Mr. Buzbee, are these your notes? Mr. Buzbee?
Mr. Buzbee?
Mr. Buzbee,
He's asking if those
these
are your notes.
You want these back? Yeah. Thank you.
And Mr. Hardin, please speak up. You're speaking softly.
Thank you very much, Your Honor. I've been mindful of my failings in this regard. Let me ask you this. On Exhibit 361, he talked to you about Lacey May's email that talked about that $50,000, correct?
Yes.
And he made a very big deal, did he not, about the fact that that this was on October the 1st, so that the jury remembers the day that the group of you went to the FBI was what date?
It was the day before, September 30th.
All right. And on the date, the date of October the 10th, is that when you sent the email or text that Mr. Buzbee asked you about to the Attorney General asking to meet with him?
It's actually October 1st.
That's October 1st.
Yes.
The gathering of all of y'all that we've talked about in that conference room where you found out about the subpoenas was on what date?
That was the 29th.
All right. And on the 29th, I think you described the mood everybody was in and the concerns everybody was. On the 29th, is that when you initially thought and talked about setting aside $50,000 for the group of you to represent Mr. Sutton, the Attorney General's office, as opposed to you as individuals?
Correct.
What was your thinking as to why y'all needed a lawyer for the university, for the Attorney General's office?
Because we were trying to navigate through this with potentially going to law enforcement. And so we wanted someone who had that type of experience at that level.
All right, you knew Mr. Sutton had criminal defense lawyer as well as previous criminal prosecution experience, did you not?
I did.
All right, and each of you, or did all of you know him for past dealings?
Yeah, I didn't know Mr. Sutton very well.
But most of you did.
It did. I knew one of his, I guess, former partners really well, which was John Ratcliffe.
All right, that at sometime that day, did you as a group decide that was not a good idea?
We did eventually decide that, yes.
Was that after you had authorized the exercise of paperwork to make it possible?
Well, what we did again was, my email was making sure and seeking confirmation that there were funds in the event we decided to do that. We did not do that. Had we done it, we've gone at length through this executive
All right.
approval.
Real quickly, if in fact you had decided to follow through on that request that had been put aside, what would you have had to do to get it authorized and done?
We would have had to go through the executive approval memo process, just like we've seen, and everyone would have had to sign off.
And that process would have been necessary before any of the funds would have been expended or even eligible to expend. Is that right?
Before funds are expended or a contract is executed.
All right. So before a contract could have been worked out with Mr. Sutton, you would have had to go through all of that. If you were going to do it on behalf of the agency, you would have to go through all that cumbersome process, correct?
That's correct.
And how long would that have taken ordinarily?
I mean, it can be done within a day or so.
All right. But in the meantime, had each of you decided that you needed to go to law enforcement, and after thinking about different agencies, different possibilities, you settled on the FBI, correct?
That is correct.
DPS had agents that he had been complaining about, correct? That Mr. Paul had.
Yes.
And so in the other agencies that had law enforcement people had been involved, such as the district attorney's office, correct?
Correct.
Objections? Your Honor, I'm sorry.
That's true. I withdraw it. All right, let me move on.
I mean, multiple leading questions. I just wish he would just ask a
All right,
question.
multiple on a
Hey,
single. My
rephrase.
problem is, if he just says objection and gives his basis and stops, it doesn't get charged in my time. But we've now had a bunch of time where these kind of speeches have eaten us up. I'll come to you at the end of my statements. I'll withdraw the statement and proceed.
Thank you, and in fairness, both of you have kind of elaborated a little bit on objection, so let's continue. But I will watch it very carefully on both sides.
Yes, thank you very much. Now, if I could, would you please tell me when it was in this process y'all decided to go to the FBI and hire Mr. Sutton personally on y'all's behalf rather than the agency?
We initially contacted Mr. Sutton on the 29th. We reached the decision that the agency doesn't need to contract with Mr. Sutton later on the 1st.
So was there ever any attempt to get $50,000 from the agency, to use $50,000 from the agency, or follow up at all on authorization?
We never started the memo process at all, which was essential to do that.
Are you aware when we're talking about computer time and everything of universal time?
Say that again.
Are you aware of universal time?
Now that you say it, I am, the concept.
I want to just get a note if I can. Do you recall Mr. Buzbee spending a great deal of time with you on both the Lacey Mays email or the attachment to the forensic report, and suggesting that it was at 1:39 on October the 1st?
I mean, the document says that. I see.
Does it come any surprise to you that if you go on the internet and check out what universal time is, which is what this was, it would have been at 8:39 the day before, not on October 1st?
That makes sense.
If what I have just said to you is true and accurate, would that have meant that y'all were still talking about authorizing the money on the 30th, as opposed to the October the 1st, as Mr. Buzbee was saying?
Yes, sir.
And regardless, when you went to the FBI on the 30th, did Mr. Sutton accompany you?
I believe so.
All right. And by that time, had y'all orally retained him to represent you individually instead of the company, the agency?
Yes, sir.
Do you have any evidence or knowledge at all that Mr. Sutton even knew that y'all had originally talked about retaining him for the agency?
I had no discussions with him.
Okay. So would it be consistent with your level of knowledge that Mr. Sutton would not even have known that y'all had talked originally about hiring him on behalf of the agency?
Based on my knowledge, that's correct.
All right. And then finally, he asked you about this one issue. He asked you about some grand jury subpoenas. At the time that the grand jury subpoenas were shared with Mr. Sutton, was he your lawyer?
Yes.
And was he representing y'all individually?
Yes.
What is your position as to whether anybody who thinks they may have a problem or need a lawyer can share the evidence or the information they're concerned about with their lawyer?
I think you can share information with your lawyer.
And did any of you give any alleged grand jury subpoenas to Mr. Sutton before you had retained him?
I did not.
Okay. Now, I want you ask, when you go to the FBI, just a couple more areas. I believe you said you have no criminal law experience. Is that correct?
When I was at Carrington Coleman, Mr. Coleman made us all take a couple criminal cases. So when I was a first or second year associate, I actually did do a couple criminal cases.
But other than that, what is your experience? If one is reporting a crime, what they believe may be a crime to law enforcement, do they wait till they're able to establish beyond a reasonable doubt before they report the possibility of a crime?
I don't think that's what you do.
When you went to the FBI, did you go with them to express your concerns and hope that they would look into it?
We just wanted to tell them what was going on.
Did you make any determination as any kind of expert on criminal law as to whether things were or were not a crime?
Not at that time, no, sir.
All right. Finally, on this area, regardless of whether it's a crime, what is your position as whether you were concerned about two particular areas specifically? Whether or not what Mr. Paxton had been doing and authorized and loosened on the world was an abuse of office. Did you have any thought about whether it was an actual specific crime for this or not? What was your thought process?
I thought I had a belief that it was.
Would you still have that belief even if it turned out this or that individual thing was not a crime?
That was based all upon what I knew at that time.
What do you mean?
Well, we knew what we knew. I mean, knowledge on that date. Therefore, based upon the actions that I discussed with you earlier today.
What was your view as to whether or not, if the Attorney General's office, when its own internal people believed the incident at issue was not a crime, if they did not, and it should not be investigated and should not be opened to the file, if your own internal people felt that way, for then somebody on behalf of the office be hired to go out and use grand jury subpoenas to punish the enemies of a friend or a donor, did you have a position whether that it was a crime or not? Did you have a position of whether that was an abuse of the office of the Attorney General?
Objection, Your Honor. That was 3 questions, and it was all 3 of them were leading.
I believe he can answer each.
Sustained.
I'm sorry. Excuse me. Sustained.
Sustained, yes.
Thank you, Judge. Did you have an opinion as to what your really hardcore belief was as to that conduct that you believed he had engaged in, as to how that complied with the oath of the Attorney General of the state of Texas?
Yeah, I believe that it violated the oath.
Why?
Because he was taking actions not on behalf of the state of Texas, but on behalf of one individual.
Against?
He was aligning against other parties, in this, against law enforcement.
Did you have an opinion one way or the other whether he was, by what he was doing, it was interfering with federal and state investigations, criminal investigations?
That appeared to be the case.
Okay. Finally, if you signed on, you authorized the intervention in June of 2020 into the Mitty Foundation case against Mr. Paul's companies, correct?
I did, yes.
If you knew then what you knew now, would you ever have authorized intervention?
I would not have.
That's all I have.
Recross, Mr. Buzbee?
Yes, Your Honor. You told us all that it was against the charity and for Nate Paul. That's what you said? The intervention?
The intervention was to intervene into that lawsuit. Yes, sir.
No. You told us, in response to the leading questions of Mr. Hardin, that the intervention was against the charity and for Nate Paul. Isn't that what you said?
I think what I meant to say, if I said that, and I'm not so sure I did, it was to intervene into the lawsuit between the two parties, and then there was also, as you know, an investigation into the charity.
So it wasn't against the charity, was it?
It was to intervene into the lawsuit.
Yeah. It wasn't against anybody. It was an intervention, wasn't it?
The intervention was an intervention.
It was an intervention that you authorized,
On
right?
June 8th, that's correct.
And you also authorized an investigation, didn't you?
I believe on the same day or about the same day, yes.
And the impeachment articles, pull it up, please, Article 1. Let's look at it. Paxton caused employees of his office to intervene in a lawsuit. You see that language?
I do, sir.
He didn't cause anything. That's something that each of the people on the executive action memorandum approved. Isn't that right?
We'd ask those people who on that memo.
Yeah. I'm asking you, you're on the memo. You approved it.
I did approve it.
Okay. So this article is hogwash, isn't it?
I think we would need more information.
And you were telling us, that those timestamps in these documents that were given to our side, at least by Mr. Hardin's office, you're saying those were universal time?
Again, I was reading the document like we all were.
Wait a minute. I'm just asking about what Mr. Hardin, the back and forth you had with Mr. Hardin. He asked you about universal time, remember?
Showed a document that had the reference to universal time.
Okay, and you were telling us that universal time, that these documents would not have been 1:30 in the morning, but would have been 8:30 prior? Or you don't know?
What I know is it is very, extremely unlikely that I was looking at any email at 1:30. Now, 4 a.m., 9:30 p.m., yes. 1:30, I don't think so.
Well, let's real quick. I believe it was 368, AG 368, if my memory serves. And let's go to the authorization email, so the members of the jury are clear about what you were up to. Can you tell us whether you had already retained Johnny Sutton at the time you sent this email to Lacey Mays?
I would need to know the conversion to the universal time.
Well, I'm not asking about that. I'm asking in your memory. We know for a fact you told us before you went to the FBI on September 30th that you met or talked to Johnny Sutton, that you retained him, right?
That is correct, sir.
Okay. Can we agree that you had retained Johnny Sutton individually before you went to the FBI?
Yes.
And can we agree that after that, according to you, and your story is now, y'all were also thinking about hiring Johnny Sutton for the office itself, right?
We were, yes.
Wouldn't that be a conflict? How the devil is Johnny Sutton going to represent you in your individual capacity and also represent the Attorney General's office when the actual client in the Attorney General's office would be the Attorney General himself?
That's why we wanted to meet with the Attorney General, among other matters, on October 1st.
You're telling this jury, all public servants, all elected, that you thought it was okay for you to hire some outside lawyer in your individual capacity and to also even discuss the office might hire him as well? You think that's okay?
I think it can be okay, yes, sir.
Would you at least agree it wouldn't be okay to have Johnny Sutton be paid for by the Texas taxpayers for your individual representation?
Yes.
That would be a crime, wouldn't it?
I don't know if it's a crime, but it didn't happen.
It didn't happen because you resigned.
No, we made the decision not to hire him by the agency.
Told us how, all this stuff was done for Nate Paul. Remember talking about all that?
We discussed Nate Paul, yes.
And you know for a fact that Nate Paul was a pain in the butt, wasn't he?
I think that's fair to say.
He was a pain. He was a constituent that wanted action, right?
I mean, he certainly emailed a lot of people in the office.
I said in the opening statement, when he said jump, he wanted you to jump and just hope you jumped high enough, right?
I think we've examined his contact with me.
You've heard the term, the squeaky wheel gets the grease.
I do know that one.
Sometimes there's in constituent services, there's somebody who's a real pain who is over and over and over demanding action. And sometimes there ain't a whole lot you can do for them. Isn't that right?
That does happen, yes, sir.
Yeah. That's how Nate Paul was. Isn't that right?
He was more than that.
Yeah. He sent letter after letter after letter after letter making threats and accusations to the AG's office, didn't he?
He did, through his lawyer and himself.
Yeah, email after email. He was incredibly unhappy with the action of the AG's office, wasn't he?
I believe at times he was, yes.
He was madder than a hornet's nest at times at the AG's office for what he called incompetence and failing to act. Isn't that right?
The best source of that would be ask Mr. Paul.
Yeah. And you know this is true because he sent you all of his correspondence that he had been sending to Josh Godbee, accusing Josh Godbee of having a conflict. Remember that?
I don't know if he sent me all his correspondence, but he did send me correspondence.
He claimed the AG's office had a conflict because the spouse of the receiver in the case worked at the AG's office, right?
If you have it, I could look at it.
Yeah.
I don't.
And he thought that was the reason Josh Godbee wasn't doing anything because Godbee had a conflict. Isn't that right?
If you could show me the documents, I could look at it.
Well, he sent them all to you. Don't you remember? And we looked at them in your direct.
We didn't look at all of them, sir.
Okay. Let's look at AG Exhibit 219, Eric. I'm just going to hit the high points. This is an email Nate Paul sent to you in July of 2020 where he was very upset, very frustrated with the AG's office. Do you recall receiving this email?
1 second, sir. It appears to be familiar, yes, sir.
He says, these emails started a month ago and continue to be ignored. See that part? First paragraph, last sentence.
I'm looking. That's what it says, sir.
Go to the next page, Eric. He's sending you a ton of different emails that he sent to Josh Godbee. Here it is where he tells Josh was your direct subordinate or one level below you?
No, Josh would have reported to the deputy for civil litigation.
Which was?
Darren McCarty.
Okay, so this would have been you, McCarty, Josh Godbee.
Yes.
Okay.
With an associate deputy to McCarty there as well.
Here he tells Josh Godbee point blank, you've exhibited highly unprofessional behavior. You see that?
Yes, I see. You've read that.
He says, your relationship with Greg Milligan, that was the receiver in the Mitty Foundation case, wasn't it?
I don't know.
Well, we all know. He says, your relationship with Greg Milligan and opposing counsels has clearly affected your ability to be neutral. You see that language?
I see the language.
He's accusing, yes, sir.
Excuse me, this has not been admitted into evidence yet, I believe.
219 is not in evidence? Your Honor, we offer 219, just to make it fast.
Any objection? Continue.
Thank you, Your
It's
Honor.
admitted to evidence.
Thank you, Your Honor. Looking at he accused the AG's office of having a conflict of interest, didn't he?
Did you read that?
Yes, sir, I did. Clearly affected your ability to be neutral. That's called conflict of interest, is it not?
It says not to be neutral. That could lead to a conflict of interest.
I'm just trying to figure out how Nate Paul had the keys, as we've been told, to the AG's office when he keeps haranguing the AG's office for failing to do its job. Any answer to that?
Any answer to that? He certainly.
Let me go to this.
Would you like me to answer or no? No?
You can answer. If you have an answer as to how we are being sold this bill of goods, that the AG's office had been handed over to Nate Paul, yet we see the real-time correspondence where he's haranguing the office over and over and eventually haranguing you. You see that, right?
Now, can he answer the question, Your Honor? Please.
Thank you, Your Honor. Let's take a look so we can end this up. Exhibit.
Your Honor, I asked those last questions then. My objections to be stricken from the record. He asked this question. He gave a speech. If one looks at exactly what he did with his answer there, the witness asked if he could answer. Do you want me to answer? And then he gives his speech about, well, if you can do so-and-so, and then he withdraws the question. So he's made a speech and testified and not allowed the witness to answer. I respectfully ask that that last question be struck and he be allowed to answer the question before that.
I'll withdraw it, Your Honor. It's fine.
I'll bet.
Finally, Eric, let's look at Exhibit 127, Exhibit 40. What is a litigation hold? What does that mean in the parlance of lawyering?
Well, what it means is when you either send or receive one, it's to not delete anything.
Does that include text?
It includes any correspondence that's relevant to the subject of the request.
Now, would you agree, I mean, you've been a lawyer for 26, 27 years?
Actually longer.
Okay.
I was licensed in 1990.
Okay.
So I think that means I'm 33 years.
33 years.
Yes, sir.
Okay. You know, as a member of our profession, that when you send a litigation hold letter, that means preserve everything related. I may be suing you, right?
That is true.
Did you know that Nate Paul's lawyer sent that to the AG's office?
Yeah, on October 11th, 2020.
Yeah, so 9 days after you left, Nate Paul is threatening to sue the office for inaction, for having a conflict, etc. Isn't that true?
I mean, this is a letter that's sent to Mr. Webster and Mr. Paxton. I'm not at the office any longer. I can read it if you have it.
That's fine, sir. Your Honor, with that, I pass witness.
Ready for the next witness, Your Honor.
Witness is excused.
May this witness be excused and of course stay available if there has to be some recall, but certainly not around.
You're excused, but subject to recall. You may step down.
Thank you, Your Honor. Your Honor, we call Mr. Ryan Bangert.
To both parties and the jurors, I plan to go to about 6:30 this evening, depending where we hit a